અચ્છા 130 કોમ્પ્રોમાઇઝ છે સાહેબ 42 ભરેલા છે 60 22 અને 20 દાડા કે છે એટલે લોકો કદાચ પેલા પૂરું થઈ રિપોર્ટ આપું છે થઈ જાય 20 દિવસ 20 દિવસ
એમાં સાહેબ ફરિયાદીના વાઇફ ઓફ થઈ ગયા છે એટલે સાહેબ 10 દિવસની તારીખ લેવી પડશે થઈ ગયું સાહેબ પૈસા ભરાઈ ગયું જી ના 12 છે જી જી એ આવશે ત્યાંથી તલોદથી આવવાના સાહેબ હા એટલે લેવી પડશે પણ એમના ફરિયાદીના વાઇફ ઓફ થઈ ગયા છે સાહેબ એટલે 10 દિવસનો સમય આપો તે દિવસે બધા હાજર થઈ જાય જી હા તો એમ જી ના હાજી હાજી જી હજી સાહેબ હાજર નથી ત્યાં અહીંયા નહીં સાહેબ કોન્ટેક્ટ કરીને બોલાવી લઈએ જી 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 સાહેબ કોન્ટેક્ટ કરી લઉં છું
हाँ बसो 16 में बीएस आवशे बीएस पर मारा 211 हाँ
हाँ हाँ भराई दी बीजू लखी दो बीजू जी हाँ भाई जी हाँ 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 ये आयुष है सुप्रीम आयुष
નથી સર.
કઈ તારીખનું છે?
સપ્ટેમ્બર.
હા હા એ સાહેબ અમારે DOP માંથી એ થાય ને
Sir.
લોકો અવારનવાર કરતા હોય છે.
ના વચ્ચે મીટિંગ હતી ને આ રાખ્યું હતું ને સેમિનાર, એ વખતે વાત કરી હતી સર. વચ્ચે હમણાં એક વખતે પોલીસ અને સરકારી વકીલોનો જે હતો ને સેમિનાર રાખ્યો હતો, એ વખતે આ ડિસ્કસ થઈ હતી ચર્ચા.
હમ. હા પ્રિલિમિનરી ફર્સ્ટ પ્રિલિમિનરી હા હા એ સાહેબ
Talking.
ને એ ના ચાલે એ ના ચાલે. પહેલા સાહેબ બે પંચોની હાજરીમાં એની હકીકત કેવી પડે. હા હા બસ હા એ ના 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 એ
That every stage must be reflected, not in a preliminary Parinama. But later on, when you write the Parinama, then you have to say that then you take your car, you sweat so blood. You take your car sweat so blood. Then you got down from the car, then we set him all of you take up behind me. Then you leave out of this, and then you pull off there, himself should have taken out something. He must have known something. So,
એ પછી સાહેબ પારડીવાલા સાહેબ નું બી હમણાં ગયા વીકમાં કે આગળના વીકમાં આવી, પણ જો કે એમાં આરોપીઓ એમને છોડી મૂક્યા, પણ પારડીવાલા સાહેબ એ 5 ઇસ્યુ એમાં સાહેબ એરાઇઝ હા એ 5 ઇસ્યુ એમાં એરાઇઝ કર્યા હતા, અને એમાં બધી જવાબદારી આઈઓ પર ને એ લોકો પર એવી કરી કે આપણે ક્યાં નાખવાનું છે.
right. And secondly, this now responsibility is further, shifted on the shoulder of public prosecutor from what? So, I want this judgment. All the ideas must be enlightened. If you look at it, if maybe I think the word we are stated on this, conduct one seminar or program, but outright the secondly, this judgment to be translated into Gujarati. Gujarati translation of the given to each and every end. If a direct certain, if you do not do it, you will have to face the risk.
ના
Right.
Please kindly convey to So the meeting, connect to other your streets. Okay, very good.
जी सर कॉम्प्रो
Okay, so we are converting two more of the. But I think a lawyer, some lawyer is coming from an hour. I don't know. But because otherwise. Like here competition.
और फरियादी ना होती
એ દિવસ પહેલા સર્વ ફરિયાદીના પતિ એક્સપાર્ટ લાવી શકાય.
Not just from work, but P89, we did our duty here. And deposit is profit, compromise is there is profit. So sir, you have completed, I think, your argument. This is three matters. That in a Mr.
Yes, go on.
Every now and then.
સાહેબ રિક્વેસ્ટ હતી એક
Yes.
સિરિયલ નંબર 4 છે સાહેબ એમાં સાહેબ એક્યુઝ જ્યુડિશિયલ કસ્ટડીમાં છે હાલ સાહેબ હું મારા પર્સનલ પાવરથી સાહેબ સમાધાન કોશિશ આપું છું એ સાહેબ બહાર આવશે એ ટાઈમ હું કોર્ટમાં બોલાય હા અધર સાઈડ બસ કમ્પ્લેનન્ટ સાહેબ પ્રેઝન્ટ છે
Okay. Then it is. Again. No. We should not take it. Why we should take it? Any problem is there?
મારે સાહેબ પ્રાદેશિક કોર્ટમાં જવું છે એટલો પ્રોબ્લેમ છે બીજો કોઈ પ્રોબ્લેમ છે નહીં મંડે સાહેબ બોલાવીને કરાવી દઈશ અહીંયા મંડે બોલાવી દઈશ મંડે કરાવી દઈશ
We are passing orders today.
જી
Your junior is there.
યસ
So your junior is going.
નહીં 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 હું પોતે જુનિયર સાહેબ
Okay, some friend is there.
પ્રયત્ન કરું સાહેબ ટ્રાય કરું જી
Friends વચ્ચે.
જી જી ટ્રાય
What to do?
ટ્રાય કરો. હા વાંધો.
वो send your friend.
જી જી.
Then you go for it.
Okay.
What is the matter? You can handle it with prayer. What is that?
302 છે સર.
Then what is the fact?
ફેક્ટ એવી છે કે આ સાળો બને એવી હતા એમણે આ જે છોકરી છે એને હથોડું મારી અને પેટ્રોલ છાંટી સળગાવી દીધેલી એવી મેટર છે.
Then what is the relationship of that?
એના પતિ છે, પતિ અને એના પતિનો સાળો બનેલી. નો સર, સરવણા ગામ છે ને એની જોડે સીમમાં ત્યાં.
This is the purpose. But in the home, there are lot of burger fits on the activity.
ત્રણસો સાત.
Each 658 અને આજે કાલે મેં વાત પણ કરી અધિક કલેક્ટર જોડે એટલે રૂબરૂ મેં કીધું ફાઇલ તમે કાઢી રાખો એટલે કાલે થોડું ફ્રી જેવું છે એટલે કાલે મેં કીધું બેસી અને જોઈ લઈ અને એમની જોડે ફાઇલ છે.
પેલું સાહેબ નવજાત બાળક પેલું લાઠી મનીષ ત્રેવીસ એટલે મેટરમાં હું નથી સાહેબ, પણ આ તો એમનો ફોન આવ્યો મારા પર, મને કે હું રજા પર છું કે જરા સબમિશન કરજો ને કોર્ટમાં કે હું રજા પર છું. મિસ્ટર વીએસ પરમાર. હા એટલે શું આપ પૂછી લેવો. હા એ તો હું કહ્યું. ના બીજા ઇંગ્લિશ હજુ કરો તમે? હા
જરા પેપર સાહેબ બધા જોઈ લો પછી આવતી મુદત એવું હશે.
498 304B.
અને ચાલે છે મારા ડિસ્કશન પણ ચાલે છે ત્યાં સુધીમાં જરાક પેપર્સ બી જોઈ લો અને થઈ જાય તો પછી હું આપને અગાઉથી કહી દઈશ સાહેબ. જી જી સાહેબ. ડેટ સાહેબ એક ડેટ લીધેલું છે જરા પેપર્સ બી જરા જોઈ લો મારી જોડે છે કે નહીં એ પણ જરાક વેરીફાઈ કરી દો અને મી ભાઈ જરાક પેલા પ્રોસેસ ચાલુ કરાવો. હા હા કઈ વાત આ રિપોર્ટ આપો કઈ વાત. હા હા હા. નવું શું આપું કે 20,000
30/4 અરે 30/10
રિપોર્ટ આપો. સાગરભાઈ કમલેશભાઈ મેહુલભાઈ ઉપર ચિંટુ.
સાગરભાઈ કમલેશભાઈ મેહુલભાઈ ઉપર ચિંટુ.
एक आरोपी अंदर कस्टडी है हाँ ये आए નથી
300 સર થઈ ડિસ્કસ થઈ ગયેલી સર ચર્ચા થઈ ગઈ છે ફરિયાદી જોડે ભલે એડજસ્ટમેન્ટ કરીને તો પૂરું કરવાનું છે.
રજૂ કરી દઉં
तो एक आरोपी आवश्यक तो खरीद नहीं जेल में जाएंगे
નહીં આવે
नहीं आवे?
બંદોબસ્તમાં એને મેચ ના
हाँ मैच ना बंदोबस्त
100 ચાલુ
अभी कभी है
ના થઈ જાય
हाँ जी
પછી બંધ થઈ
हाँ क्या हाँ हाँ
જી સર એમાં સાહેબ સુકલજી એવું કહેતા હતા કે વારસદાર જોડ્યા છે એવી વાત હતી. ઓકે હા તો સાહેબ નેક્સ્ટ ટાઈમ આપી દઈએ દલીલ આમાં કે રિટર્નમાં આપી દઈશ નેક્સ્ટ ટાઈમ એક ડેટ આપો શોર્ટ આપી દઈશ. આમ તો સાહેબ એક્સરસાઇઝ જ છે આ આમ તો 1993 10 રૂપિયાના સ્ટેમ્પ પર એક વેચાણ કરાર થયું એના આધારે 2007માં દાવો કર્યો છે એટલે લો પોઈન્ટ પર ડિસાઇડ થયેલો છે નીચે સાહેબ. શુકલજી મેં કહ્યું કે આમાં તમે કહું બે જાણીએ છો બધાનો સમય જાય છે. મારે તો સાહેબ આમ તો લિખિતમાં શોર્ટમાં આપી દઈશ હડકી તો ચાલે એવું છે. એક શોર્ટ ડેટ સાહેબ રાખો એવું તો હું આપી દઈશ લેખિત મને વાંધો નથી. હા જી ઓકે 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 હા રજૂ કરી દઈશ સાહેબ. ના આપી દઈશ લેખિતમાં શોર્ટમાં આપી દઈશ નો પ્રોબ્લેમ. બીજું સાહેબ 34 હતું એક આરસી બીજી 34 બીપી પટેલ છે એટલે કોમ્પ્રોમાઇઝ મારા સાહેબ 2-3 વખત ટાઈમ લઈએ છીએ અમે પણ એમાં પ્રોગ્રેસ નથી સાહેબ ટીલ ટુડે. હા 90 એમાં સાહેબ અમને પૈસા આપીને દસ્તાવેજ કરાવવાનો છે ત્યાં અટક્યું હતું. હવે આ મીનવાઇલ શું થયું કે શ્રાદ્ધનો જે સમય થયો ને એટલે કોઈ લેવાલ હોય આ 7 નું બાદ ગણતા હોય એટલે એવું હશે કે નવરાત્રીમાં કદાચ બેઠક કરીએ એમ એટલે ટાઈમ ત્યાં ગયો છે, જોઈએ હવે એ અરજી બરજી આપશે, વાત થઈ છે તો પછી એકાદ તારીખ સાહેબ પડશે વાંધો નહીં, પણ નેક્સ્ટ ટાઈમ જો ન થતું હોય તો પછી પ્રોસીડ. જી
હા કોમ્પ્રોમાઇઝ.
નરેશભાઈ નીનામાં
એપ્રિલ નંબર 1 ગુજરી ગયા છે એટલે ગઈ વખતે આપીશું આપણે. એપ્રિલ નંબર 1 એપ્રિલ નાથા બી ગુજરી ગયા અમારા એ ગુજરી ગયા, એમને આપીશું. ના સુધારો કરો, સુધારો કરો અને એપ્રિલ સુધારે એપ્રિલ અરજી આપી વખતે આપી દીધી. આ જોઈ ગયા લાલ પેન લાલ મનસુખ જોઈ લઈએ આપણે બે તારીખ ઓગણીસ વાળી 90 વાળી રિટર્ન આપી છે પણ ઓવરઓલ થોડી કરવી પડે એવી છે. હા કઈ તારીખ? હા હા ઓકે હા ગુરુવારના ગુરુવારે અમદાવાદ શુક્રવારે રાખીશ દિવસે પબ્લિક
Yeah, for 7 and 8 numbers, sir. For revision application. 15 to 20 minutes, sir, not more than plus or minus 5. May I start here? Please. Is it witness pura karo? I have no objection. I can wait further, sir. To witness, I can wait. Acha, okay, please. The 7 and 8 numbers, revision application number 100 and the revision application number 102. I will be hearing both together. One is for Mr. Pandya appeal.
अरे पंड्या साहब आता सुनावणी થઈ ગઈ હતી અગાઉ,
Which has already been heard. So I will be
મુદત માંગી છે.
I will be adopting his argument. I have gone also. I have seen on the YouTube. I will not waste. I have seen gone through what are the queries. Apart from, I will categorize, sir. The accused during the course of the bail also, the High Court also was the view, and this what also was the view. The accused should be categorized into the four types of accused. type 1, 2, 3, 4. Type 1 will be the first person who is shown as an accused number 1, Kishore Bhai. Sorry, I apologize, accused number, main accused, who has procured the paper. Now, during that investigation of the Kishore Bhai, while he was arrested from the place of offense, the CCTV footage is there and everything is there. They come across a second set of accused persons. The second set of accused persons are the 4 to 6 accused persons, namely one Agrawat and one relative of the Kishore Bhai, that type 2 of accused persons. They met with this accused number Kishore Bhai, who has procured the paper from the list. They all sat together. They conspired. They decided that we want to, you bring this the paper. We will print the paper. We will take a photocopy of the paper. We will circulate it to the other persons, and we will take monetary benefit of it. This type and type 2, which is a Dangar, one accused namely Dangar also. This type 1 and type 2 of accused were conspiring way before registration of the FIR. Now comes the type 3 of an accused person. The type 3 and 4 interrelates. 4 will be the students who have procured the paper, who, as far as my case, will be the victim of that offense. And now the state has also realized that they are the victim. Type 3 will be the relative of the victim. Let us assume that I am going to sit for an exam. Someone contacts my father. This is the father, uncle, mama, or whoever it is. There are several sets of relatives. And say they kabhi tamara chokra exam appear thawanu chhe. That contacted by the type 2 of accused. And do you want certain paper or anything? Then obviously my father is going to say that okay, or whatever it is. So they will be fall under type 3 of the accused, who are not student but the relative of the student, who has either by way of the allegation of the prosecution is who has by way of money, they have given the money or they have given certain security. That is the allegation. Now the authority says that while arresting a type 1 of accused, while arresting type 2 of an accused, we have taken the statement of the type 2 of the accused, who are the main conspirator and the person who has procured. And from their statement, we say that type 3 has given this amount of the money, and type 4 has benefited out of this, as they have given examination. How that is what the case lies. Examination was conducted on 12th of December in the year 2022, 21, sir. On 17th, this all came to know. There is a statement of one accused, one witness, who was also one of the victim, type 4 victim, who was later on made a witness of the prosecution, named as Pinakin Barot. If I may read his one statement, which will say how and in what manner, because he has been made a witness, he himself has procured the paper. Pinakin Kumar Bharatbhai Jate Barot. It has been applied from the charge sheet paper. I will not waste the time. There are 3 charge sheet and whatever the idea that the court has entered into. રૂમમાં પૂછવાથી લખાવું છું ઉપર બધા ઠેકાણે રહું છું સોયનસો I will skip. ગઈ તારીખ 11/12/21 ના રોજ સાંજે 6-7 વાગ્યાની આજુબાજુ મારા ઘરે હતો. પરીક્ષાની તૈયારી કરી રહેલો હતો. તે દરમિયાન મારા માસીના દીકરા સોયનસો, one of the co-accused, નાવે મને ફોન કરી જણાવેલ કે આવતીકાલે 12/12/2022 ના 1 લાખની પરીક્ષાનું પેપર છે, જેમાં મારા મિત્ર કેતનભાઈ મારફતે જય પટેલનો સંપર્ક થતા જય પટેલ મને મહેશ પટેલ નામના માણસનો નંબર આપેલો હતો અને મહેશભાઈ મને પરીક્ષા અગાઉ પેપર આપવાનું જણાવે છે, તો આ પેપર અગાઉથી આપો પરીક્ષા હોઈ શકે કે કેમ તે બાબતે પૂછેલ, જેથી મેં મારા વિવિધ પરીક્ષાઓ પાસ કરેલો અનુભવ આધારે કહું છું ગૌણ સેવા પસંદગી મંડળનું પેપર અગાઉ મળવું અશક્ય નથી, પ્રયત્નો પણ કરી શકાય નહીં. ત્યારબાદ જણાવેલ સોયનસો. So this is the manner it has. Now FIR was registered under section 406, 409, 420 and 120B. Later on, only one section was added, that is 201. That during investigation, some of the accused person have said they have tried to destroy the evidence. Now, I will not enter the 201 part. 406, 409, 420, and 120B. The case of the prosecution says that since inception, we are of the view that 409, 406, 420, and 120B is there. So my case will be that we will have to read only FIR and charge sheet. Because in FIR, they said that this is the offense which is being made out. They had ample opportunity by way of 3 charge sheet to justify the offense under 409, 46, 420, and 120. Now the case is that there is a conspiracy. We were part. So may I read the section 120 capital A, which says that if I may permit it, I will do digital. iPad nahi aata. I apologize. I read 120A, sir. Of for a moment. So side note, સાહેબ એના પછી બે પેપર લીક થયા ને એની અંદર જે the people who have made accused, it has nothing to do with this. In Baroda, there is one paper leak in Baroda. There is also one in Surat, the GSEB in PGVCL. There they have only made 5 or 6% accused. Because after this they have realized the students are now the victim, they are to be made witness, and this person has to be made an accused. So this was just ground zero for them also, for investigating authority of state of Gujarat. Sir, 120 capital A, definition of criminal conspiracy. When two or more persons agree to do or cause to be done an illegal act, which is there, or an act which is not legally by means such an agreement is designed a criminal conspiracy, provided that the no agreement except an agreement to commit an offense shall amount to criminal conspiracy unless some acts beside the agreement is done by one or more parties, so and so. When two or more persons agree to do or cause to be done, as and when you invoke 120B, the moment it is invoked, whether it is in FIR, in charge sheet, or by way of additional settlement, you have to show on that day, while invoking 120B, that the persons you are naming or person who are you are alleging against 120B, prior to alleging 120B, they have acted in this manner. There has to be conspiracy, then an act. There can never be first act, then we will decide whether it was a conspiracy or not. That is not coming out of from anyone. That persons before this code are the type 3 and 4, either relative or the student. Now, how, in what manner they have said? Let us assume that I and my brother, we are two persons. My father procured paper for me. So what they say is, my father has worked as an agent to procure paper from the type 2 persons who are doing this for the purpose of monetary benefit. Though the allegation against my father is that my father has paid certain amount or has promised to pay certain amount in lieu of the paper. So this is that promise to make a certain amount in lieu of the procuring the paper, we will consider you as an agent. Just to mislead the court and mislead the court and judicial authority to fall under 409. The people they are calling agent. Please. That is why they have introduced the word agent, because initially there was also an objection to the 5409 is made out. Now, 120B they have invoked, they have failed to show that apart from 3 accused persons who get together, to 4 accused persons who got together, who decided to earn monetary benefit, there being one Agrawat, one Dangar, one Kishore Acharya, the charge sheeted accused person. I can give them detailed name also. Apart from these 4, no one has conspired to leak the paper. 4 of them, yes, there is 120B because there is a prior conspiracy. No one is denying that. Conspiracy can never be after act. It has to be established before act. That is why the language itself says when 2 or more persons agree to do, the act has not been done yet. And that agreement the authority has to show by these sets of accused persons. How and in what manner before procurement of the allegation is that procurement of paper, that is an offense. Please, sir. Please, sir.
There is no agreement between both of them, and this is not extension of conspiracy.
No, sir. Extension of conspiracy cannot be there. That is what again. The case of the prosecution is like amne paper. May I read the FIR, sir? It is very. Potana. That is what my case was. Since inception, it was there. TV રીતે કે so and so, I will skip that part. હુકમ આવ્યો તે આધારે સચિવશ્રીના પત્ર દર્શાવેલ તેમજ દૈનિક પત્રોમાં પ્રકાશિત માહિતી અંગે અંગત સૂત્રોથી ખાતરી કરવા હિંમતનગરના ધ્રુવ so and so, વિરાટનગર ખાતે રહેતા પિનાકીન so and so, સતીશ ઉર્ફે ધ નેમ ઓફ ધ પ્રાંતિજ તાલુકાના ઊંચા ગામના રહીશ જયેશભાઈ પટેલે કોઈપણ પ્રકારની ગુજરાત રાજ્ય ગૌણ સેવા પસંદગીના મંડળ દ્વારા 12/12/2021 ના રોજ આયોજિત હેડ ક્લાર્કની પરીક્ષા ભાગ 1 ની બી સિરીઝની પેપરની નકલ પરીક્ષા અગાઉ મેળવી તારીખ 11/12/21 ના રોજ ઊંચા તારીખ પ્રાંતિજા રહીશ જસવંત અરગોન પટેલ તથા તેના પુત્ર દેવલ પટેલના આપતા મેળવી In FIR, they said Mirwin. So they are not aware whether in what and how manner it has happened. My case is that their allegation against is that these people procured the paper. Now the query of the court that these people agreeing to the fact that whether they will, the board would be part of the conspiracy or not. So there won't be part of a conspiracy. Once again. Please, sir, I have gone through section 10 of evidence. Act. The last time also the query was raised. I have gone through that also. I may read, sir. Please, sir.
In their illustration, in their conflict, and later on, he was completed in it.
I may read, sir. For anyone.
Their illustration said that those
Things to be done by conspirator. Please, sir.
ignorant about other aspects, but he may be said to be part of it.
Merit, sir. I have gone through that. That is what I also say. Please, where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such person in reference to their common intention. Here they refer to 34 also. Common intention after the time when such intention was first entertained by any one of them is relevant to the fact as against each of the person believed to be illustration. Reasonable grounds action believing that A has joined in conspiracy to wage a war against it. For 121, 131, this will reasonable A. One will be for only 121, 131 of the IPC, because these are the only two offenses where even not committing an act but conspiring to do an act is an offense. 121 and 131. There are no other offense where I can be tried. If I say that khun kari desh, so that won't amount to an offense. But the moment I say that I will wage a war against the state of India, that will amount to offense under 121, 131. Even me saying so. 5062 said dhamki api. No, 5062 foreign. Yes, sir. 504, 5062, 506, and 5062. In Vikram Johar versus state of Uttar Pradesh, they have elaborated that it has to be in a manner, not by mere saying a word, it won't even amount to 504. Please. And then there has to be some enmity. Please, that is why I have not yet. He has not started arguing. I have no enmity. Please, sir. Now come to the B. The fact that the B procured arms in Europe for the purpose of conspiracy. C collected money in Kolkata for the object. D persuaded person to join the conspiracy in the Bombay. Published writing advocating the object in view of the Agra, and F transpired the Delhi to G at Kabul. The money which C collected at Kolkata, the contents of the letter written by the H given an account of the conspiracy are each relevant both to prove the existence of the conspiracy and to prove A's complicit in it. To prove A's complicit in it. Although he may have been ignorant of all of them, and although the person by whom they are done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left, this has to be for A. That is what I am saying, sir. These sections are to be read only for the purpose of 121 and 131 of the CRP, IPC. No, sir. We are not shying away from the fact. What we are saying is what will happen. Whether the intention of prosecution is to prosecute all the person, or whether the intention of the prosecution is to prosecute a person and convict them. To prosecute, yes.
Thank you, sir.
So that was the last time Mr. Pandya has already said there are 3 charges. Qua certain charge has been framed, qua certain charge has not been framed. They are also under after the framing of the charge, it has been here, the trial has not yet gone. So that part also be there.
This section says that one can enter into conspiracy at any point of time.
Please, sir.
It is not necessary.
But sir, this has.
They must be in the beginning.
Please.
Later on, anybody can join the conspiracy.
But sir, section 10 limits itself.
Ignorance of the fact is here because.
But section 10 will limit itself. Things said or done by the conspirator in reference to common design. Here the illustration also protects up. Here it is embarked into the Evidence Act for the purpose of 121 and 131. I may once again read the 121 and 131 of the IPC to clarify the court's dilemma. Yes, sir. Title said, waging or attempting to wage a war or abetting the waging of the war against the government of India. The only section in the IPC where attempt to commit any offense Please, sir. Now to prove that whether that A, B, C, D, the illustration, they have attempted and to prove their case against 121, and in 131 there is a mutiny, that the attempt into mutiny in the army. There, to satisfy the concept of satisfy the purpose of the attempt, section 10 has to be read. Not in the IPC offenses of 406, 409, 420. The intention of section 10 is to common design. There has to be design. They are not saying to do an act. There is just a design. The design amounts to attempt. That is why section 10, that if there is one common design to commit an offense. So I am not saying that 10 will be invoked. Qua the main person who has procured and the person who am involved in the offense. Illustration does not say that the person who has used the gun and who has committed the offense, for instance, is to be read with the 10. Because 10 is limited to, guys, I have researched this on the respect because I was on it, and that is why I am aware. Please, that is why it is there. So 10 will not be there. Conspiracy will limit itself to 120A, and it has to be prior the conspiracy. Now the reason is there is an order of the trial court, which I am adopting all the arguments of my learned seeker because I will not waste the time of the court. Because there is no reason order has been passed. Now, when I say that 406, 420 is not made out, 409 is not made out, 120B in this manner is not made out, there has to be reasons to satisfy this point, because we are at the framing, we are not in a bail court, or we are not in an, we are at the framing of the charge. I am challenging the bold charge of the prosecution. Argument of the prosecution has to be detailed in a manner that how and in what manner against this person who has preferred an application under 409, this 409 is being made out, because they have opened their case in 226. Now they cannot shy away from the fact that they are still investigating, or they will put in the way of delations. Please.
Degree of proof is very low. What section says?
Please, sir. 227. Please.
This kind of draft to proceed.
Please, sir. For
Draft to proceed further. It comes to the neighbor. Then once you look at the FIR and other material along with the drafting, that is tries to give indication to the court that there are ground exists for proceeding.
please, sir.
So the level of proof or degree of proof is so low that even with limited material.
Please,
there is a-
please.
So
Abhay,
therefore, here you cannot be level of whether he would be acquitted or convicted. That level has not. to be-
no. I am also on that aspect. I should not be decided whether I am acquitted or should I be convicted or not. I am on the aspect whether the evidence, the prima facie sufficient charge sheet. I am charge sheeted.
Because-
Charge is being no, sir. That is I differ.
Section says, section did not use for prima.
Please,
Prima facie is of a little bit, higher level of or degree of.
please, sir.
Whereas here legislature deliberately use the word, there must exist ground to proceed further.
Yes.
Now, ground to proceed further is a degree of proof which is even lower than prima facie.
I'm saying that there are what my case is that the grounds, when the charge sheet has been filed, charge is being framed, magistrate is to consider whether these are the valid ground to proceed further or should blankly follow the charge framing of the charge.
You sell it down.
Please, sir. There is one judgment. I'm on the same ground. That is why.
Therefore, legislature were very, very intelligent.
Please.
They said that favor lawyers like you, you come out with favor adjective to be-
Yes, we will. We will with the last argument in the discharge. Yes.
So therefore, there is
Even otherwise,
not want to add any adjective to it. There is a that there must be ground to proceed further.
even
Beyond that, they don't want.
on the academic side, not related to this case, even we would also submit that if you say that there is valid ground of dissent, go to the trial and conclude it. Now, if you say that go to trial, conclude it, get acquitted. There is no, you cannot limit by discharge by saying that this offense is not made out against me, or this is made out against me, you charge me against this. There can never be the argument in the discharge. What am I saying? I cannot never say, sir, let us assume when I argue the 409 is not made out. So am I accepting the fact that there 406 and 420 is also made out against me? A discharge can never be on the aspect that these offense is not made out, but yes, this offense is made out. As a prima facie charge sheet is there, I as an accused is saying that these grounds are being made out and these are not made out. I'm not asserting that whether I should be acquitted or convicted. What I'm saying is the moment the charge has been framed, I have been read the charge. I say that you have not produced the valid reason to charge me with the 409. For 409 and 406, 420, I say that they do not, you are not cheating, and 120B conspiracy is also not there. When you say that there is a conspiracy of 120B, that is why we are charging you with the 409 with the other accused. There I am saying even in the conspiracy, you have not produced the document to charge me qua that. I'm limiting myself to the fact that though I am being charged, I'm not being charged of the proper offense. That is why there is one judgment of a 2-page judgment. I'm relying on Honorable High Court, sir. If sir, may read the next page of the head notes and sir, thodu dicey. We never rely on the head notes. Paragraph 2, sir. It is a fact of the case. I will skip that part. Paragraph 5 is in sub 226 and 227 discussion. Paragraph 6 is a relevant, sir. May I read, sir, paragraph 6?
Yes.
Considering of the case first under 227,
Directly come to
the paragraph 6, 7, 8 सब थोड़ा paragraph
they
છે.
have the section they have.
नहीं, paragraph 6, sir, 6. पाछड़ ना पाने.
Alright, I'll go to that.
I am considering on that only. The 6, 7, 8 is relevant, sir.
Okay.
Considering I am not on the fact of the case also.
Okay.
Considering of the case first under section 227 and then under 226 of the crucial procedure. It is a stage where court would be in position to find out the case worth trial. Non-existence of a sufficient ground for proceeding with the case would help the court weeding out the worthless case, thus saving the crucial public time which can be invested in a case worth trying. Thus, expediting the case worth trying, consequently curtailing the delay. The exercise under 227 in its letter and spirit would also relieve an apparently innocent person or the person against whom the material worth trying does not exist of the agony of the avoidable trial. This court would hasten to add that under section 227 of the court would not be required to appreciate the material as if asserting the non-existence of the guilt of the accused. Only exercise expedited would be expected would be to peruse the record of the case and the document submitted therewith to find out necessary material leading to the document submitted to ingredients of a penal provision of the person accused is sought to be charged with. The court would not be justified considering the evidentiary value of the record of the case and the documents. That is, I'm not reading, sir. Eventually, sustainability of the charge is not the test contemplated under section 227 of the CRPC. The court would be merely required to lay its finger on the material consisting the ingredients of the relevant provision of the person accused in the charge. In the instant case, the court below was obliged to find out the presence or the absence of the material concerning the ingredients of the 120A or section 34 of the IPC. It did not find any such material, nor learned APP is able to lay his finger on the material evidence, the meeting of the mind of the accused for doing any illegal act or any other act which may not be legal. By illegal means, he is also unable to lay his finger on the material evidence in the common intention, act so and so, so and so. The petitioner consideredly did not possess, use the arm of the commission of an offense, and there were. That is why the case will limit. No, sir. Yes.
And I'm ready to purchase it and
No, that is not coming out of anywhere. Authorities know by saying that I mean, there is not a single evidence in the charge sheet which shows that by why and in what manner are you accused. Co-accused says, because I co-accused no statement says. The further it says that, if I may read, sir, paragraph 10 also. The learned APP, however, when submitted as the frequently telephonic talks between the accused number 1 and accused number 3 as evident by the call details, rendered sufficient evidence for charging the accused for offense is question. He would contend that the mobile phone in the question belonged to accused number 2 and it was used in the commission of offense. The mere existence of the call details in absence of the cogent material evident making the calls between the two accused for the purpose of committing the offense under section 120B or 34 of the IPC, in the opinion of the court, would not be sufficient material for trying. Sorry, sir. Please, sir. No, please, sir. Please.
now here material is there. That after agreeing with the original conspirator, it is plus to that. Agree to have the paper.
Who says that, sir?
Now, for that section, it says that because there are several judgments of
Please.
conspiracy, saying that conspiracy are as in the secret.
Please.
Therefore, court can extract the details.
Please. But here it has been extracted, sir. Here it has been extracted. That is why I started my argument. Initially, 1, 2, 3, 4, they have divided. The prosecution has elaborately proved their case in by way of charge sheet that one has procured the paper, and type 2 in how and in what manner they have raided the place of the meeting. They have also collected the CCTV footage before the offense of the meeting of that accused person. This person which I am saying, I am not saying that none have done this offense. Their meetings have also been established at that time. The applicant before this court have nothing to do with the offense. That is why I point in section 10 say design, common design word is used. here in part of at the making design, these persons were not type of an accused.
But they have further than design.
No, sir, they are not further.
By agreeing that yes, this purchase the paper will help you.
Please. No, allegation is that, sir,
Both the
please,
area,
please, sir.
both the parties are illegally gaining something from this finance.
For that,
Both the parties are gaining. Students are gaining that will get in the exam.
please, sir,
Actually will be gaining that will get some material benefit.
please, sir.
So here both the sides, material gain.
It will fall under which offense of IPC, sir? That is our question. Which?
So why extension of 120?
Yes, but
Here
which?
you are cheating.
Please.
The-
Let us assume I am at the stage of the prosecution as on this material prosecution has proved this stage. I am at the stage of in what I will be convicted. Let us see, I can be. I am not saying that my lords may enter into the court, this court may enter into this argument. Conviction or acquittal. I am not saying. I can.
There are right now sufficient material
Please.
to resume or to proceed on the ground that yes, all were involved in the. Okay, now this is over. You conclude your.
Argument. I am concluding on this only. Another is that let us assume I make an application before this court. Now this court has got the ready of section 10 or whatever it is. That has to be done by the trial court who is framing the charge. It cannot stereotypically reject an application. And my prayer would also be that whether to consider this application on my merit or to remand it back to the magistrate so that he can give the detailed reason. Because at the end of the day, he is the one who has framed the charge. This court in revision has to be limited aspect, whether the order passed by is legally correct or not. Apart from legality, this court cannot go on to the facts of the case. Yes, but what my case is that the proper if then order is basically found. I am saying it is improper. If court while examining finds it that yes, it is an improper, there is no specific.
Not only the High Court, Supreme Court, it says that by framing the charge,
Please.
magistrate is not bound to pass a detailed order. But whatever he does, from it should be reflected that he has properly applied it. Detailed order is not required.
I'm not seeking this while framing of the. I'm seeking while I'm seeking an application under discharge. My contention has to be touched. He cannot say. He cannot even see the. He may, for an example, if I rely on this judgment, the court will say that this judgment does not apply to this case. That is expected from the court. We do not say the elaborative in how and what manner this judgment is. That we do not expect. But ignoring the whole judgment and delivering and not relying upon this judgment, that amounts to illegality in order. That I must say that content. I'm not saying that why my lords are not relying. This court is not relying on it. I have read the paragraph 6. Give your opinion on paragraph 6. I'm not seeking that. The court can simply say the applicant or advocate has relied upon this judgment, and by reading of the facts, this court is of the view that it is not material. That can be a valid reason. I cannot have, but not touching that judgment, it is illegality. For that, we have no objection. If this court is remanding the matter, we will argue it out afresh by limiting ourselves on the aspect of 227. We are not shying away from the fact that 227 is a wide scope. It is a very limited scope and very narrow scope, but there is a scope. And the intention of 227 is to curtail the innocent person. We are not saying that you do not prosecute against it. We are saying that you do not prosecute against it in the cases which there is no material to you to charge us. No, sir. Please. Grateful. This is one judgment. I'm relying upon other judgments of Mr. Pandya, and also I'm adopting the argument of Mr. Pandya. Wholly. So I'm not wasting the time on the fact of the case, whether what is the stage of a trial and everything. Sir. એક જ જજમેન્ટ છે સર બે એમને આપેલા છે સબ્જેક્ટ એમને મને કે ભાઈ આઈ સો ઇટ ઓન તો there is only one judgment I'm feeling because આપણે say સાહેબ ટેકનોલોજી નો ઉપયોગ કરવા અમે જોઈ લીધું એટલે મેં નથી હેરાન કરવા સાહેબ please sir sometimes what happens we limit by saying this and court says that આટલું જ આર્ગ્યુ કર્યું છે બીજું કઈ લખ્યું નથી that is why I'm emphasizing I have also adopting yes and apart from that these are please sir thank you grateful sir grateful for patience hearing
બારકામનું ચાર્જશીટ થઈ ગયેલું છે એનો સીસી નંબર 684 નો પડેલો છે અને એનું તોમસ નામું સાહેબ તારીખ 4/10/22 ના રોજ ફળવામાં આવેલું છે એની સર્ટિફિકેટ કોપી મેં નામદાર કોર્ટમાં સાહેબ રજૂ કરેલું છે અને આ સદર કેસ સાહેબ પુરાવા માટે આવી ગયેલો છે ઓલરેડી ફરિયાદી સાહેબ બોલાયેલા છે સાહેબ એટલે અત્યારે હાલ સાહેબ આ રિવિઝન જે કરી છે સાહેબ એ હાલ ના પૂરતી સાહેબ માનવા લાયક નથી સાહેબ અને જે પુરાવો પડશે એ નામદાર કોર્ટને સાહેબ ન્યાય આપવાનો છે સાહેબ 409 લાગુ પડે છે નથી પડતી, બીજી સેક્શન લાગુ પડે નહીં પડે તો સાહેબ એક્વિટલ નેચરની કોર્ટ છે એટલે પૂરા પર સાહેબ મેટર આવેલી છે એટલે સાહેબ હાલ નહીં આ સાહેબ રિવિઝન છે નામંજૂર કરવા છે સાહેબ. અને જે આરોપીઓ જે 3 જે રિવિઝન સાહેબ શું રોલ છે સાહેબ મેં કોપી રજૂ કરી છે ત્રણે. હા
I was under the impression it has not been produced.
આરોપીઓ
But,
સાહેબ
now it
આનો
has been
શું રોલ છે સાહેબ આખો બધો ઇન્વેસ્ટિગેશન નો એ
If
શોર્ટ
this
માં સાહેબ
document is
માહિતી
produced, I am
આપો.
relying. Oh, I am relying on this document then if it produced. Now the prosecution has come up with the case to protect their charge. That this is the role of the person who has approached this honorable court. Now, once again, I will say that the court to examine this now, because as they have produced, the court is to examine. Examining the document or examining the prima facie, they are only this document which authority is relying upon that say that this is how in what manner the charge is valid. Can I be prosecuted under 409? Because every document says that there is a state on the basis of statement of co-accused, on the basis of statement of co-accused, on the basis of statement of co-accused. Apart from statement of co-accused, they are not relying on anything. So the document which my learned senior friend has produced, it runs into 5 pages, sir, where they have categorically all the revisionist, સાહેબ revisionist ના નામ છે, એના બાજુમાં એમનો આરોપી નો રોલ દરેકના નામ છે. In each and every, I have gone through it. In each and every, there are no produce any cognate evidence. For 120B also, nothing is there. So in that, my argument. And they are also relying on statement of co-accused. And my case emphasizedly will be there on the basis of statement, I cannot be sent to trial. Even in 227, court has to examine that. Whether on the statement of basis of co-accused, can I be sent to trial? Please, sir.
સાહેબ પેપર ફોડવામાં તો ઓલ ગુજરાતના કેટલા વિદ્યાર્થીઓ રખડી પડ્યા હતા આઉટ જિલ્લામાં સાબરકાંઠા તો કચ્છમાં આપ્યા હોય અને એમના આખા કોપરના કારણે આખા વિદ્યાર્થી સાચા વિદ્યાર્થીઓ જે મહેનત કરતી એમનું ખૂબ સે બન્યા થયેલું.
સાહેબ એના પછી 2 પેપર ફૂટે આફ્ટર ધીસ અને એમાં કોઈ વિદ્યાર્થી આરોપી નથી કારણ કે એમાં they realize કે ભાઈ એમાં 6 જે લોકો છે who are actually gaining monetary benefit. It is an easy to argue કે પેપર ખરીદવું ગુનો છે, but at the same time સાહેબ કોઈ પણ અવેલેબલ હોય ને તો no one will shy away from that.
સાહેબ પૈસા ખરીદીને
સાહેબ 32 વર્ષની
પેપર
ઉંમરે આપણે
આપેલું.
બેરોજગાર હોતા હોઈએ ને સાહેબ અને બહાર ફરતા હોઈએ ને ત્યારે કોઈ કહે ને એટલે
I have seen the people that they would not know. You forget about it.
Please.
You more or less they will.
that is to a certain extent it is right, sir. But when you are 28, 29, 30-year-old, I have seen, sir.
I have seen even things that they don't.
એ સાહેબ એ જ અમારો જતો રહ્યો
Because the elites will always.
સાહેબ હવે તો એવું થઈ ગયું છે કે તમારી જોડે આઈફોન ના હોય, you are not supposed to walk out. પણ પછી એ લેવા માટે તો સાહેબ બહુ ખરાબ પરિસ્થિતિ. The time has changed. Please, sir. Grateful. Order. I may be excused on that day, sir.
Okay. Yes, Mr. Patel.
જી સર સુધારો કરી દીધો સાહેબ
અચ્છા.
એટલે સુધારે આપેલી અરજી આપવી પડે ને
હા.
એપેલેન્ટની સહીઓ સિગ્નેચર લાગુ કરી દીધી.
હા. Monday night. Monday or Tuesday, Monday or Tuesday.
ના મંડે ના આ તો અઠવાડિયું જોશે અઠવાડિયું. આમાં શું છે સાહેબ એપેલેન્ટો બધા અલગ અલગ જગ્યાએ છે એટલે પાછી સહીઓ સિગ્નેચર લેવી પડે ને સાહેબ એક જ ગામના એક જ જગ્યાએ નથી સાહેબ. 1 week હા 21 શનિવાર ચાલશે 21. જી સર.
સાહેબ એક બીજો 6 નંબરમાં છે એમાં સાહેબ મારા રિટર્નમાં તૈયાર કરવાનો બાકી છે. મારા થોડાક ફેમિલી પ્રોબ્લેમ થયા હતા એના કારણે 1 મહિનો 19 2013 એ એમની થઈ ગયા પછી 25 આમાં સાહેબ થોડી 19ની જેમાં લાંબી આપવા વિનંતી કે મારા અધૂરા લખાયા છે અને થોડું મંચ વધારે છે આમાં એટલે પહેલા વીકમાં ના સર વિધાઉટ ફેલ હું રજૂ કરી દઈશ એ ટાઈમે એટલે એક થી 3 માં એટલે હાજી 1 નવેમ્બર હાજી આપણે